where everything's going. We need it. Okay.
You ready?
We're ready. Hey, real quick, item number 15 on your calendar, does it show it going to Finance, Ways, and Means?
It's right in here.
15, Finance, Ways, and, well, hang on, not 10.
All right, good afternoon. If you're confused, you are in the House Criminal Justice Committee full. If you need to be someplace else, you're here. It's Wednesday, April 10th, 2024. Welcome. Madam Clerk, will you take the roll, please?
Representatives Carringer, Davis, Doggett, Farmer, Fritz, Glenn, Hardaway, Howell, Johnson, Lamberth, Moody, Russell, Towns, Vice Chairman Gillespie, Chairman Hulsey. Mr.
Here.
Chairman, you have a quorum.
Thank you very much. Members, do you have any personal orders? Seeing none, let's jump into the calendar. By the way, before we do that, item number 8 on the calendar, which is House Bill 1947, is rolled 1 week. And item number 9, which is House Bill 2302, is also rolled 1 week. Brings us back to item number 1 on the calendar, which is House Bill 1600 by Chairman Williams. Got a motion and a second, sir? You are recognized. I'm showing 2 amendments. Do you?
Thank you, Chairman, members. There are multiple amendments that filed, but the amendment for the purposes of rewriting the bill for the entire bill is drafting code 018173.
You have a motion and a second. You want to attach it first?
Please, sir.
Okay. All those in favor of attaching attaching amendment 018173 to House Bill 1600, say aye. Opposed, no. Ayes have it. It is on the bill, sir.
Thank you, Chairman and members. This bill, House Bill 1600, is amended, began in my local community with my District Attorney General, General Dunaway, and I'm happy to say that the law enforcement community across the state has worked diligently to help me try to weave a path as it relates to the bill that you have before you. What this, to give you a little background as to how the bill started, there were 2 young individuals that were adjudicated delinquent in the Speaker's district and Senator Bailey's district for plotting an active shooter situation or terrorism at a school in their community. The parents found the plan and did what good parents do. They notified the other individual about the plan, the other individual who was going to do the plan with their son, and they notified them and said, "We're taking our son to the law enforcement agency to turn him in with the plan. We want to let you know." The other parents followed suit, took the 2 boys there. They were eventually adjudicated delinquent in the courts for those crimes. They weren't tried as an adult for those crimes because the parents did the right thing, brought the kids in, and did that as well. What this bill would do, this bill would allow for the court clerk in our communities to notify once a juvenile has been adjudicated delinquent of a crime, that those case files would still remain preserved based upon the adjudication of that juvenile court. However, that court clerk would notify within 3 days of the adjudication found guilty in a criminal court. They have 3 days by which to submit that to TBI's TICS system. That TICS system then would set a date out in the future until that individual's 25th birthday, of which they would not be able to purchase a handgun, which would be, or any gun, until the age of 25. The purpose of this bill, and a lot of people ask me why 25. I have a 22-year-old at my house. I too once, many years ago, was a 22-year-old, and science and medical community would tell us that a young man or woman's frontal lobe is not fully developed until they're 25. That is the reason why I chose the age of 25. What this bill also does is amended. It says if the juvenile chooses to, they can petition the juvenile court of which they were adjudicated delinquent of said crime and ask for a hearing in chancery or criminal court in order to have the TICS notification lifted. That lifting of that TICS notification follows the minimum standard of proof, which is the preponderance of evidence, so that those individuals can get their rights restored as it relates to that. The whole purpose behind this bill is twofold. One is to put a little bit more time between, if for instance, if those two individuals were 17, they were adjudicated delinquent, and their courts were sealed at their 18th birthday, they could turn around some 9 or 10 months later and purchase a weapon. This would prohibit that until the age of 25. There are, for clarity, there are 16 other states in the United States that have similar laws that do this. The whole idea is that we also, in high crimes areas across the state, what we would be able to do is, for the first time, the juvenile court judge, district attorney, would be able to tell a young individual who's perpetrating crimes, sometimes directed by adults to do so, which we do try those adults, but there would be a repercussion for their actions, therefore going after their 18th birthday, which we think will help reduce overall crime in those high crime areas. With that, Chairman and members, that's the entirety of the bill before us. I will say these, to tell you about the crimes, these are aggravated assault against a first responder or nurse, criminal homicide, robbery, aggravated burglary, cruelty to animals at a felony level, and threats of mass violence. With that, Mr. Chairman and members, I'm happy to answer any questions you might have.
Thank you, Mr. Chairman. Representative Johnson.
Thank you, Mr. Chairman. I want to thank the sponsor for coming to me about a question that I had. Was visited by TBI as well. They seem to think that this would not affect voter registration during that time. Did you get to talk again with the Election Commission? Have you heard the verification from them?
Yes, Representative Johnson. Because of the way juvenile cases are adjudicated, I will say, to our credit in Tennessee, we have one of the most stringent juvenile court systems in the United States. We have a system that works. It's really in every category in adult court where someone's rights are to be preserved. We do that in juvenile courts as well. The difference with the juvenile adjudication is those cases are sealed, and so if they did commit aggravated burglary, it's not on their record. And so therefore, when they go to register to vote, it's not technically a felony. So their rights to vote would still exist.
Thank you, and I appreciate you checking on that.
Yes, ma'am.
Any other questions for the sponsor? Representative Fritz.
Thank you, Mr. Chairman. And sponsor, thank you for bringing the bills. I just told you, I really support what you're trying to do. I think it makes sense. And I think that the appeals part of that makes a lot of sense. The two questions I'll offer, that if I can't vote for it today, I need to get a good answer on the military service. As the bill says that you can't possess or purchase. If we had a kid who had committed one of these egregious things and they were able to join the military, would they be a felon in Fort Campbell? Or would they, if they were Tennessee Guardsmen, be a felon if their duties required such? And then that definition of alcohol, what is addicted to alcohol? I couldn't find anything in code as to exactly what that means. Maybe legal could help us with that. But again, thank you for bringing the bill.
Go ahead.
Thank you, Chairman. Thank you, Representative Fritz, for the questions. To the tenet of your first question, I appreciate you asking me that question. I did have an opportunity to take a look at the statute as it relates to their service to our military, and you and I both don't want to prevent anyone from serving our military. But in the same vein as Representative Johnson's question, this is not registered as a felony conviction on their case file. It simply prohibits their ability to purchase a weapon. The the recruitment officer might be able to better answer that question, but in my view, it's obviously not my intent that I would ever prevent somebody from serving. But in my view, what would happen is if the military or the National Guard were to run a background check on said individual, if they're under the age of 18, it would probably be useless, to be honest. But if they did run one, then it would be flagged on ticks, but then they would look for a juvenile or a record, and there wouldn't be one that exists. So for the purposes of that, there's not really a felonious event which would prohibit them from acting in service to their nation. Secondly, your question about addicted to alcohol, it's actually a really good question. I think the definition is a little bit vague, but I do think from the intent of the sponsor, the addicted to alcohol would mean that someone has a counselor or mental health substance abuse individual has deemed, or the courts have deemed because of your actions, that you are addicted to alcohol. I don't think it would be one of us telling someone that would be, but my understanding would be a counselor or the courts. Thank you.
Representative Hardaway.
Thank you, Chairman, and thank you to the sponsors, especially for your acknowledgement of the immature brain, is a short way to put it, that frontal cortex is not fully developed until somewhere around 25, and we have to start acknowledging that in young adults if we're going to truly deliver justice and be able to rehab them with the proper deterrence, proper rehabilitation, and proper punishment at times. Okay? Just a couple of questions. At this moment, I support your bill, sir, wholeheartedly. I'm going to try to keep my heart in it when you answer these questions. And I think you've spoken to one. You're saying this is about gun rights only. It's not about voting rights or citizenship.
That is correct, sir.
All right. And the level of proof is preponderant, sounding like you're rubbing off on me. Preponderance of evidence.
Thank you, Chairman. As it relates to the restoration of that, when the juvenile, now adult, chooses to petition a juvenile court in which they were adjudicated delinquent in order to lift the notification from ticks, that level of proof is the preponderance of evidence. As it relates to the actual offense itself, the standard is much higher as it relates to the juvenile courts for good reason. It would be so, and so that standard is only for the restoration component.
All right, thank you. And are we speaking of a single incident? If there are multiple incidents where the youth has been adjudicated, is that going to make a difference in how the law is applied?
Thank you, Chairman. This would be enacted if there was only one violation. Multiple violations of these heinous acts, which are listed here, it wouldn't be any greater punishment. It simply is a notification to tick. So if it were 1 or 100, unfortunately, if that were the case, it would still only be one notification to the 25th birthday, and it would expire at that birthday.
All right. And the addiction to alcohol, in my review, I didn't see other drugs addictions listed. Did I miss that?
Thank you, Chairman. It does not clearly state any other addiction other than alcohol in the current statute.
Is it possible we can address that at some point as we move forward?
Good. Thank you, Mr. Chairman. The answer to the question is I'd be delighted to. I think in the purposes of what Representative Fritz shared earlier, maybe a definition of not just addiction, but also the things that one could be addicted to would be important for the purposes of clarification more than anything. But obviously, we are in the last calendar and the last hearing of criminal. And so I don't want to substantively change the bill outside of this room. So I don't think personally, it's not my intent or yours that it would be a substantive change. It's mainly clarifying purpose.
Very good. And my last one, this could be the determinant. I didn't see domestic violence or didn't hear you list domestic violence when you spoke to disqualifying convictions.
Go ahead.
Thank you, Chairman and members. It doesn't specifically say domestic violence. It might be a question you might want to ask for legal. However, it does have statute in there. I just listed the few that were enumerated in there, but it also has a clause where it discusses those aggravated crimes as it relates to Title 39. And so I believe that might be the case, but I'm not 100% certain.
Thank you. And Chairman Halsey, if at some point we could go out of session and hear from legal on that particular question, please.
All right, without objection, we're going out of session. Legal.
Michelle Fogarty, Legal Services. Could you please repeat the question?
Whether domestic violence would be one of the disqualifying offenses.
It is not listed as one of the offenses for which a juvenile would be prohibited from a firearm.
Could it be under one of the catch-all clauses?
The offenses that this bill applies to are aggravated assault against a first responder or nurse, a violation of Chapter 13, Part 2, a violation of Chapter 13, Part 4 of Title 39, a violation of Chapter 13, Part 10 of Title 39, aggravated cruelty to animals, a threat of mass violence, or a violation of this title involving the use or display of a firearm. If the aggravated assault or the violation involving the use or display of a firearm involved a domestic abuse victim, then that would, of course, be captured. But just the offense of domestic assault itself is not included in this list.
Okay. That's all I had, Mr. Chairman. Just a follow-up question with the sponsor when we go back in.
Any other questions for legal while we're out? If not, we're back in session. Representative Hardaway, your last question?
Yes, sir. Whether the sponsor sees fit to be specific about domestic violence, and according to legal, right now you're only covering domestic violence situations that involve firearms. So is it possible that you can state your intent if that would make a difference? And I guess we'd have to go back to legal at some point, figure that out. But I'd ask you to explore ways to include domestic violence.
Okay, go ahead.
Thank you, Chairman. Thank you, members. Thank you for the question. The answer to the question is what we were trying to do is to look at the behaviors of juvenile, of the crimes that were committed by juveniles, and the predictability of them repeating those as offenders as they turn 18. As it relates to domestic violence, the reason why domestic violence with a weapon is included is because that action, we believe, determines future actions because of the behavior that they did before. The domestic without a weapon, whether it's a knife or whatever, the domestic was not the same standard that we had before. It was even though you and I could easily agree that that's a terrible thing, for the purpose of this bill, it's not included. I'd be happy to look at it and see if it makes sense to do that. But back to your other question, I thought I would answer it. The federal law currently, as it relates to regulation of permits, federal law prohibits addiction as it relates to substances as a excluder of someone's ability to be able to purchase a gun. So the federal law in this case, as it relates to addictive substances, would supersede or be the protection necessary for your previous question.
All right, thank you. And Mr. Chairman, I'm just going to follow up merely that we did enumerate animal cruelty. And I have a hard time especially since we know there's some similarities in predictions back and forth on animal cruelty and domestic violence, child abuse, that they're all going to have a connection. So I would encourage the sponsor to figure out how we address domestic violence, period. Thank you. Thank you, sponsor, for the bill. I am supporting it.
Thank you. Thank you, Chairman. Thank you, Representative Hardaway. To answer your question, it relates to cruelty to animals. The original statute did include a misdemeanor offense for cruelty to animals because I too believe that if someone was to commit a crime or cruelty to animals that are misdemeanor offense, that it would be something that we'd want to look at. But in the same way, it is a lesser misdemeanor crime. So is domestic violence. What we were trying to do is get to those areas that were of a greater penalty in the adult statute. And so that's why cruelty to animals is not in here, but aggravated cruelty to animals is in here. For the same purposes, domestic violence is not in here, but aggravated domestic violence is in the statute. But I'd be happy to discuss it with you after between here and the floor.
Thank you so much. Next on my list is Chairman Doggett.
Thank you, Mr. Vice Chair. I've got a couple questions for you. So they commit an offense listed here in this bill at the age of 16. When they become an adult at 18, is there a reporting component that must be met until age 25? I mean, are they coming back before a judge throughout this process to assess how they are living or how they are behaving at this point? Can you walk me through that or explain that to me?
Yes, thanks, Chairman, or Vice Chairman. Yes, Chairman Doggett. The revision to the bill that is intact, that's different than your criminal subcommittee, is that in discussion with law enforcement agents and stakeholders, what we wanted to be able to do is so that much like we do in other cases, give an opportunity to restore those rights for those folks who had made a mistake in the earlier and completely changed their lives and the system was working and they've gotten settled into adulthood. What it would do is that individual would petition the same juvenile court in which they were adjudicated delinquent of that crime and request a hearing in a chancery or criminal court at the age of 19 for the purposes of restoring that right. There is a window or period of time between 18 and 19 where they couldn't restore those rights, but because of a crime that might be committed at 16 or 17, we felt like that duration of time was reasonable as it relates to the restoration of those rights. Once the hearing is requested through juvenile courts and the hearing is set in chancery or criminal court, then that individual would have the lowest standard of burden of proof to be able to restore that right, of which they could then therefore purchase a weapon.
Thank you, sir. Nothing requires them to come back at 19. So if they wanted to come back at age 23, they could do that at that point.
Yes, sir.
To have this hearing.
Mm-hmm.
What happens at age 25?
Thank you. In discussion with the TVI, much what happens is when the court clerk's office notifies TBI's ticks, once it's put on there, a date is set of which inticks of which is equal to their 25th birthday, and when that date comes, then that date falls off, and then they can purchase from then on.
Thank you.
Yes, sir.
All right. Next up, we have Representative Towns.
Mr. Chairman, thank you. As well, thank you, sir, for the bill and the thought processes going into it. I too would be concerned about these additional drugs, meth and all this other stuff, opioids and all this other stuff that really clouds the judgment of anybody, not just young people, at some point, whether or not this is going to be broad enough to capture that and prevent them from being able to purchase, 18, 21, et cetera, et cetera. And the question becomes, Chairman, whether or not, if you want to fix it, we should be able to do it here. I would imagine if we suspend the rules and do what we need to, plus we're so close to getting out. If you think it's neat, if you think it's warranted, we should be able to fix it and include it. And there again, domestic violence is a very serious problem, especially if it's aggravated. But you're saying that aggravated is already covered at the federal level, is what you're saying?
You're recognized, sponsor.
Thank you, Chairman. Representative, the current statute is currently covered for aggravated cruelty to animals under Title 39. And if the challenge that we have is, as you probably know better than I do, the challenge of getting to this podium is being able to manage input as it relates to certain offenses. I would venture to say I would be delighted to discuss with you the possibility of adding others, but I, among many, would need to be convinced as to why that might be necessary.
Representative Towns.
Well, let's do that. And this is the least that we should do. In the event that we don't get everything we want now, you're coming back. You plan to be back. You plan to return, correct?
Lord willing.
Always, always. Very well said. And we should look at it next year and try to tweak it and improve it, because certainly it needs to be done as it relates to the brain development of our young people. You know, I think it's spot on. And but if we don't get what we think we really need to get, we need to look at it early in the year and get it done. Mr. Chairman, thank you.
All right. Are there any other questions? Seeing none, we're going to go ahead and vote on House Bill 1600. All those in favor, say aye.
Aye.
All opposed? All right. The ayes have it. This goes on to finance.
Thank you, Chairman and members.
All right. Next up is item number 2, House Bill 2702 by Representative Littleton. There she is. All right. You have a second or a motion, a second, and I see that you have an amendment, Representative.
An amendment, it is 018187.
That is what I have as well. All right. You are free to continue to explain the amendment.
Thank you, Mr. Chairman. As amended, it authorizes a juvenile court to transfer a child to be held and tried as an adult if the child was at least 14, was at least 14, but less than 17 years of age at the time of the alleged conduct and charged with an offense that would be a felony if committed by an adult and involving the use of a firearm or attempt to commit such offense with a firearm.
Thank you very much. Do we have any questions on the amendment? Are we ready to just go ahead and add the amendment onto the bill? All right. All those in favor of adding amendment 18187, say aye. Aye. All those opposed? All right. The ayes have it. The amendment is on the bill. Sponsor, you are free. Or do we want to go and take some questions?
Thank you, Mr. Chairman. Yes, the amendment did make the bill. I did want to say that we studied the juvenile justice system a couple of years ago of the ad hoc committee, and this is one of the bills that came out of that. So this is, I think it's very important that we study it and see where we go with this.
All right. Thank you so much. Are there any questions from members? Representative Johnson.
Thank you, Mr. Chair. So is this bill, is it now permissive?
You're recognized.
No.
Okay. One more question. What crimes are being added that were not transferable before?
And I'm being told that it is permissive, so I don't know if that clarifies anything or if we need to go out of session for legal.
That'd be,
Sponsor.
it was before, but I thought with the amendment it changed it. But yes, if we could clarify, that'd be great.
All right, we're going to go out of session to hear from legal. Legal, you reckon?
Michelle Fogarty, Legal Services. This is permissive. It gives the juvenile court the discretion to decide whether or not they want to transfer a juvenile who has been charged with an offense that would be a felony if committed by an adult involving the use of a firearm.
All right. Does Representative Johnson, do you have another question for legal?
Well, just the one about what crimes are being added that were not transferable before.
The only one that is new is an offense that would be a felony if committed by an adult involving the use of a firearm
Thank
or an
you.
attempt to commit that offense.
Thank you.
Any other questions for legal? Representative Hardaway?
Thank you, Chairman. And thank you, Chair Lady. You mentioned study. Does that mean that there's a reporting mechanism included with the amended version?
Just 1 second, Representative Hardaway. We are out of session still. Is this a question for legal or for the sponsor?
Legal.
Okay. You're, go ahead.
Whether there's a reporting mechanism requirement in the amended version.
Michelle Fogarty, Legal Services. There is no reporting requirement.
Representative Hardaway?
Okay. All right. I'll wait till we're back in for the sponsor. Thank you.
All right. Any other questions for legal? All right. We are back in session. Representative Hardaway, you're recognized.
Thank you, Chairman. And same question, Madam Chair.
Sponsor, you're recognized.
Thank you, Mr. Chair. I misspoke. I meant that we have studied this in the ad hoc committee. Instead of that we're going to study it, we studied this for weeks. We brought in all vendors and all the people that we could think of to help us with the ad hoc committee for juvenile justice.
And could I assume that our juvenile court judges are okay with this?
You're recognized.
I haven't heard from any of them.
Representative Hardaway.
Thank you, ma'am. Thank you, Chair.
All right. Representative Towns, you're recognized.
Thank you, Mr. Chairman. Madam Representative, with the bill, will there be some kind of tracking mechanism on with the study of how many kids, obviously their ages, their ethnicity, other pertinent information, so we'll have enough data to analyze? Is that included in this bill?
You're recognized.
It is.
Okay, very well. Thank you.
All right. All right. Leader Lambert?
Move previous question.
All right. Previous question has been called. All those in favor of passing House Bill 2702 to finance, say aye. Aye. All those opposed? All right, the ayes have it. This bill is going to finance. Thank you so
Mr. Chair and
much.
committee.
All right, next up, we have House Bill 1128 by Representative Powers. Representative, you're recognized.
Thank you,
And
Mr. Chairman.
it looks like we do have an
committee.
amendment here.
Yes, I actually had several that had been drafted, and I threw them all away except one. And the drafting code is 018044.
That is what I have as well. Motion. All right, we're going to go ahead without objection, add the amendment to the bill. All in favor, say aye. Aye. Against? No. All right, that bill is the amendment is added. Sponsor, you are free to explain the bill.
Okay. Thank you, Mr. Chairman and committee. And I'm actually filling in for the main sponsor who is not here today, so take it easy on me. But the purpose of this bill is to provide data that will ensure the Attorney General has standing to bring suit against the federal government if they deem necessary. This bill does three things. It requires a jailer and arresting law enforcement agency to collaborate to verify citizenship when a person is arrested in this state. It requires the keeper of the jail to report persons who are not lawfully present, and it defines not lawfully present within the United States. We know that illegal immigration is not a victimless crime, and we are aiming to capture data on only a small portion of the number of illegal aliens in this state. And with that, Mr. Chairman, I renew my motion.
All right. Any Representative or Chairman Doggett, do you recognize?
Thank you, sir. Are we on the amendment or are we on the bill as amended?
Believe we're on the bill. We are on the bill as amended.
Okay, very well. Thank you. And Mr. Sponsor, I recognize that this is not your craftsmanship on this bill, but the original bill had some troubling language, at least that which I'd found, and so does this amendment. In the amendment, there's several things that are listed to use to provide evidence of, I guess you could say, legal or lawful presence here in our state. But there's one provision down at the very bottom of section 1, which is listed down there as C. If an individual cannot produce the documentation listed in subsection B1, which is where all of those certificate of citizenship, birth certificate issued by the U.S., a state in the U.S., and so forth and so on, says then a law enforcement officer, excuse me, or jailer may presume that the individual is lawfully present in the United States based off of their personal knowledge of the individual. And so, in other words, if you do not have any of the, excuse me, if you don't have the required documentation to prove your presence, then you are to be presumed as being here. And I do have issue with that. And I'd spoken with the sponsor and about this a couple weeks ago. And I think the other amendments had fixed that, but this is what we got today. And I do have issue with that.
Thank you. And if it's okay with the chair, we have the Department of Safety here that I've been working with on this amendment. And if you don't care, could we go out of session and hear from him at this time and to clarify this particular area?
All right. Yes, that is fine. We have Ben Boyas from the Department of Safety. We're going to go out of session and hear from him. You know the procedure, sir?
Thank you, Chairman. Ben Voitis, Legislative Liaison with the Department of Safety. Just happy to answer any questions.
Chairman Doggett, you're recognized.
Thank you. Can you expand? I don't know if you heard the question or statement that I made about the inability to provide necessary documentation that there's a presumption that you are here legally. Is there anything that you can expand upon with that? Or
Yeah, thank you, Chairman. I don't have any information on that. Our only concern with the bill that was addressed in this amendment is to make sure that the right entities would get the report the information to the DA's conference. And that was our only concern with the amendment.
Follow up? All right. Representative Johnson?
Thank you, Mr. Chair. Yeah, recently there was another bill that was passed by Rep. Gant about reporting. How are these two bills going to work? How do they work in conjunction with each other?
Thanks, Representative. I'm not sure. I would have to get that information for you. I'm not sure at this moment.
Follow
Okay. Okay. I would actually, before this gets to the floor, like to hear about that because I have some concerns about how those two bills will act in concert with each other. Thank you.
All right. Anyone else have any other questions for the guest? No. All right. We're going to go back into session. I don't see anyone else on my list to speak. Does anyone else have any questions for the sponsor? Sponsor, would you like to say any more?
Please. Yes. Thank you, Mr. Chairman. And to Chairman Doggett, when I looked at that too, and I looked at it a little bit earlier, it looked like this may be a typo. I mean, to me, that looks like that particular phrase may presume that the individual is not lawfully. Would that is that correct? Is that the way you're reading it right now? That maybe just that word was a typo that was left out?
I think it would be a whole lot better if it said not, if they could not produce that documentation, they are not lawfully present.
Yeah.
But it does not say not, it says,
Okay.
yeah.
And just a question to the committee chair. I mean, this seems to be a technical or a typo in that particular area. Is there any way to put a verbal amendment on it this time to correct that?
Unfortunately, we do not do that. And committee, just one moment. There's a list building here. I saw Representative Fritz first.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing it. I was going to ask the same question, is could we put a verbal amendment on this so that we would correct what we think we're trying to do?
All right, so we are going to be having a calendar next week. It seems like, based on what I'm hearing up here, would you mind rolling this 1 week to make those changes?
No, not at all. I was thinking this might be the last calendar or in the last meeting. So that's why I asked for the verbal amendment.
All right, we're gonna go ahead and roll this 11/28 to next. We're gonna roll House Bill 11/28 1 week.
All right. Thank you, Mr. Chairman.
Thank
Committee.
you. All right, next up, we got House Bill 2471 by Representative Raper. Motion, second. Representative, you are recognized, and I see that there is an amendment.
Yes, sir. It is 017956.
That is what I see as well. All right, all those in favor of adding amendment 17956, say aye. Opposed? All right, that is added. Sir, you are recognized on the bill.
Thank you, Mr. Chair. First of all, I want to remind you that I came about a week ago and presented this bill, and Chairman Hulsey politely pointed out that there may be some code violations. We met with legal. They kindly changed it, and it actually, the bill is more friendly now. But the purpose of this bill is to give latitude for judges to transfer 16 and 17-year-olds to adult court when criminal gang activity has taken place. Criminal gang activity is defined by TCA 40-35-121. And there are presently three categories of criminal gang activity. One is that when the offense is so egregious that that the judge has a prerogative to transfer at 14 to 17 years of age. You also have another category less egregious, and that is 16 and 17 years of age. And then you have the remainder of those, which they would be waiting to adult court at that time. And what I'm trying to do is really eliminate the third category, add offenses to the second one. To allow judges more prerogative and latitude as far as transferal is concerned. And we are basically eliminating the third category. The Sheriff's Association endorsed the bill because we amended also the language that the transfer can only take place if there's room in the adult facility. And reminder, this is not a mandate for the judge, but they still have the latitude to keep the juvenile if they choose. That is a summary of my bill, and I'll submit to questions at this point. Thank you.
Okay, thank you, Representative Raper. And by the way, we had some problems in the committee with the bill, and you worked to fix it, and I appreciate that very much. Any questions for the sponsor? Representative Johnson.
Thank you, Mr. Chairman. Is there a section of this bill, section 1, that deals with those under 14?
Yes, but yeah, could you ask legal that question? Because
Sure.
I asked before and I don't remember the exact answer to that. Could we go out of session and ask legal that
All right,
one,
without
please?
objection, we're out of session, legal.
Michelle Fogarty, Legal Services. Section 1 of the bill is for juveniles who are 16 and 17 years of age.
Okay, is there any section of the bill that is for under 14?
No, Section 2 of the bill deals with children who are transferred and then detained. But that would apply to any child transferred and detained. So in that respect, yes.
Okay, I guess what my concern was and my question was is like if so we're talking about a 12-year-old that is involved in something that's considered gang activity that they really didn't consent to, but they didn't have much of a choice to be a part of. Is there anything that allows for something like that situation?
No, not in this bill.
Thank you.
Any other question for legal while we're out? Representative Hardaway.
Thank you, Chairman. Just want to put on the record, have legal say it also. This maintains judicial discretion, period, across the board. Is that correct?
Michelle Fogarty, Legal Services. Yes, it is within the juvenile court's discretion as to whether or not to transfer juveniles charged with these offenses.
Thank you, ma'am.
Question for legal? Representative Davis.
Thank you, and I appreciate that. So just to clarify, because Section 1, we just were told only applies to 16 and 17-year-olds. And then when you read the very under subsection I, it says when a child transferred under this section is detained. So when they're talking about 16 and 17-year-olds, when they're transferred and detained, it doesn't reference anything under that age, correct? Or am I confusing things?
Michelle Fogarty, Legal Services. Section 1 of the bill amends a specific subdivision of TCA Section 37-1-134 that only applies to juveniles who are 16 and 17. Section 2 of the bill amends that same statute as it applies to any child who is transferred.
Okay, thank you. Thank you for that clarification. I just want to make sure I understood. Thank you.
Any other question for legal? Seeing none, we're back in session. Sponsor?
Representative Johnson, I apologize. I misunderstood your question. I thought you were talking about the whole thing as far as 14 to 15-year-olds, but this has nothing to do with that. That stays the same, and we're only talking about 16, 17-year-olds. So thank you, but I apologize.
Representative Towns.
Mr. Chairman, thank you. Mr. Representative, however, in her question, there's another concern that we may not be addressing. We may need to look at gang activity. The little that I know revolves around many times young people being bullied and forced into a gang. And so if you have a young person and their parents know, uncles or whomever the guardians know, that they are involved in this gang against their will and they're afraid to get out, what kind of cover and protection do we have for these kids? And it happens often across the country. Okay.
Go ahead.
Yes, sir. A very good question. This goes back totally to judges' prerogative. They know the history of the child. They know the family history if they've had another one in there. They know what interventions have already taken place. So at this point, it's going to be prerogative of trying to rehabilitate, trying to offset any of those problems that we're talking about at the younger age. So it goes back to, again, we got to put our trust in the juvenile judges. Yes.
Go ahead. Mr. Chairman, and to a degree, I would, acquiesce on that. However, there's so much going on in our community with young people and crime and things that are horrible across the country. Okay, even across the world, as I research and see this stuff. Okay, there's a different tack that they take on how they act out. And so what that tends to do is many times as adults give us an attitude of, we're going to knee jerk and we're going to come down as severely as we possibly can to try to get their attention in order to stop it. So it doesn't work necessarily. However, what the judges may or may not be astute as to what's going on with the kid. Many kids are bullied, and what they do, they go back to the schools and they go to these institutions and they try to hurt somebody with a gun because they're bullied. But they're bullied, but they're afraid. They're in fear of their body being harmed. And and some of these adult prisons, don't misunderstand me. You got to be punished for what you do, especially when you go to the extreme. I believe that. But in some of these adult prisons, with some of these kids can even exacerbate the condition even worse. Because if they're not really truly rehabilitated, they become better, more maniacal at whatever it is they're going to do once they get out. And so you don't want, you want to kind of separate the wheat from the tare. And I think we need to, if we don't spell it out, the judges may or may not do what we want done. And I know it's not your intent or my intent to try to further compound the problem with them. And we're trying to solve some things. We're trying to really solve some things. That's at the core. That's what we want to do. All of us, we really do. But, and if we don't take it in consideration at this point, we get data, we need to look at it. And if need to be modified, modify it. Whereas that child that's been traumatized by his classmates or his folk in the neighborhood that's, doing certain things. And these kids can be pretty brutal. It can be pretty mean and nasty. So that's the reason many of them, they're pressured and they pick up something to protect themselves. They put something in their pocket. Now, it's not the right thing to do necessarily for a child, but it's a human thing to do because it's self-preservation. And as I was taught by my old man, is the fact that anything will try to live, even a microscopic organism. When you take a lot of antibiotics, it's another, the germ tries to defeat the antibiotics. It's trying to live. And it will do it. That's a principle in life, that anything will try to live. And so they're trying, at that point, trying to live that situation out. So I want you to consider it if you don't mind, Mr. Representative. Thank you, sir.
Leader Lambert.
Move previous question.
Previous question been called. We're voting on House Bill 2471. All those in favor say aye. Aye. Opposed, no. Ayes have it. Goes to finance, sir.
Thank you, Chair and Committee.
Brings up item number 5 on the calendar, which is House Bill 1881. Representative Campbell, you have a motion and a second. You're recognized, sir.
Thank you, Mr. Chairman. Just for the record, I would like to state that I've had a fully developed frontal lobe for going on 2 years now. So very excited about that. Thank the good Lord.
We are too.
No, sir, it is not debatable. Members, House Bill 1881 would increase the penalty for assault on a law enforcement officer to a Class E felony, and that's what the bill does.
Any question for the sponsor? Leader Lambert.
Just thank you for carrying the bill. I mean, look, our law enforcement officers are out there and they work hard every single day. They put themselves in harm's way and they literally lay their life on the line. If somebody's being arrested and they are taking umbrage with that take it up with that officer supervisor, take it up with the court system. You can file a lawsuit, you can fight it out in the court system, do what you want to, but don't fight it on the side of the road. I mean, just don't assault our police officers. They're in a very sensitive position and it just is extremely dangerous for everybody involved if you wind up having somebody that is an assaulted an officer. I will mention that a good number of other states in the country already have laws like this on the books that carries much more severe penalties. This just knocks it up just one notch, which is why this bill has a lower fiscal note on it than other versions have in the past. But thank you for carrying the bill. It's an extraordinarily good bill.
Representative Johnson.
Thank you, Mr. Chairman. So this bill also includes first responders, right? So this is.
Go ahead.
Thank you, Mr. Chairman. So we had some discussion with the Senate on that, and in its current posture, we had a previous amendment and some other things. And actually, I'll give a shout out to Vice Chairman Gillespie. We had some conversations on some different things that were also going to be included in that amendment, but the Senate was not willing to take up what we had previously, unfortunately.
Okay, so you're telling me that that's no longer.
It is no longer part of this
bill. Okay. I'm thinking about what happened yesterday in the Senate when I think troopers were trying to remove people from the gallery. And a lot of times if you pull your hand back or something like that, they say that you are assaulting. And, very often that's the charge. And then you go to court and what they find is that no, based on the videotape, you were not. And I think that there's some concern that just something like that what is considered an assault can be incredibly broad. So I was just wondering if legal could maybe tell us about that broad definition of assault in this situation.
Without objection to go out of session. Legal.
Michelle Fogarty, Legal Services. An assault is a person commits assault who intentionally, knowingly, or recklessly causes bodily injury to another, who intentionally or knowingly causes another to reasonably fear imminent bodily injury, or who intentionally or knowingly causes physical contact with another, and a reasonable person would regard the contact as extremely offensive or provocative.
Okay, thank you. So you also included there, they don't have to actually touch anybody, but the person on the receiving end feels like they are in danger. Is that correct?
It's a reasonable person standard. A reasonable person would regard the contact as extremely offensive or provocative, or there's a reasonable fear of imminent bodily injury.
Okay, thank you.
Representative Hardaway.
Thank you, Chairman. To legal, what does the bill do in terms of definition for first responders?
Michelle Fogarty, Legal Services. In regards to definitions, the bill separates out law enforcement from the definition of first responder and provides a separate definition for law enforcement officer.
And would that be for this particular section of the law, or will that go into other areas of current statute?
The definition only applies to TCA 3913-116, which is currently assault against a first responder or nurse. If this bill were to pass, it would be assault against a first responder, law enforcement officer, or nurse.
Okay, I'm going to ask whether first responders are included then in this bill in terms of assaults and the penalties that go with, and the increased penalties that go with the assault charges.
Michelle Fogarty, Legal Services. What the bill does is it provides a higher penalty for assault against a law enforcement officer as opposed to assault against a first responder or nurse. Under this bill, assault against a first responder or nurse would be a Class A misdemeanor, which is current law. This bill separates out law enforcement officers and states that assault against a law enforcement officer is a Class E felony with a mandatory fine of $10,000 and a mandatory minimum sentence of 60 days. The current statute defines first responders to include law enforcement officers. And under current law, an assault against a first responder or a nurse is a Class A misdemeanor, and it is punished by a mandatory fine of $5,000 and a mandatory minimum sentence of 30 days. So this is just separating out law enforcement officers and increasing the penalty if the assault is against a law enforcement officer.
All right, so in essence, we're taking law enforcement officers and defining them as such in this bill, so that the increased penalty only applies to them as opposed to all of the first responders or nurses.
That is correct.
Okay.
Other questions for legal?
Thank you.
Okay, we're back in session. Any questions for the sponsor? Sponsor, you and I have discussed this, and I must go ahead and present my position here. We have tried to be consistent, or at least I have, over these issues. There's already law in existence with aggravated assault. This is simple assault, and I have real problems with with making special people under the law. And for example, if a police officer's walking out of the post office and there's a lady on her lunch break who's walking out beside him and somebody shoves the police officer and shoves her as well, those are both assaults under existing law. But under your bill, if it's passed, because he shoved the police officer, he gets a $10,000 fine and a mandatory 60 days in jail. But when he shoved the lady that's on her lunch break, he gets a Class A misdemeanor and maybe a $500 fine and might serve some jail time or none. And so what we've done, if we pass your bill, is we have said that by law, we're going to make one person more important than another person. And to me, that is a very precious thing to me, to keep the purity of equal justice. Because that's what we say, and that's what we ought to hold to, is that justice applies to people equally. Doesn't matter who you are. It's equal. So I have real problems with enhancements over that issue of equal justice. So I can't vote for the bill. I understand where your heart's at, and I appreciate it. 36 years in law enforcement, but I knew what I was getting into. And I appreciate the effort, but I can't be in favor. Chairman Doggett.
Thank you, Mr. Chairman. Sponsor, is there a presumption here that the reason that this law enforcement officer is being assaulted is because they are a law enforcement officer?
Go ahead. Yes, sir, there is. And I think, Mr. Chairman, if I could just go on here for just a second, I think what we've seen, and you can look at the fiscal note and see how high it is. We have a real problem. And our law enforcement officers in our communities across the state, they are being targeted. You can see that. And this is an attempt to say, as a body and as a state, that if you assault one of our law enforcement officers, that we're going to take it very seriously. So, Mr. Chairman, thank you for the question. And yes, that's where this comes from.
Go ahead. Thank you. I will say, I've seen instances where law enforcement officers were assaulted, or punched in the face, or what have you, and a person the defendant is arrested and go to booking and find out that they're being charged with a misdemeanor. And their exact statement was in front of me, it was just a misdemeanor. I'll beat the brakes off of them next time because it'd still be a misdemeanor. So I thank you for what you're doing.
Under current law, by the way, a judge has every right, and the leader's bill not recently passed it, that you get 11 months and 29 days. You get a year in jail for that same assault. Leader?
Well, Mr. Chairman, I like the way you're thinking there. But I will say this, just to clarify, and I know Mr. Chairman, I deeply appreciate your perspective on this bill, but it is only if it is a law enforcement officer who is discharging their duties at the time. To Chairman Doggett's point, it's not just an officer to have be walking down the road doing something else. These are folks that are being assaulted, intentionally assaulted, because they're serving us in uniform. And Mr. Chairman, I know you did that. You served us in uniform, so I know this is kind of a sticky wicket for you, sir. But I do hope everybody else supports it, because while you were out there walking a beat and riding in a car and protecting your community, it just should not be fair game for anybody and everybody to assault an officer and get the exact same penalty anybody else gets. We do hold you all in higher regard. I treasure our law enforcement officers in this community. I know we all do, but it's a little something more we can do to protect them. And so I know, Mr. Chairman, to you, everyone is equal in the eyes of the law. They are to me as well. But we do ask some folks to do certain special jobs where they just absolutely should be protected. So I just want to throw it out there that it is only while they're wearing that uniform, while they're discharging their duties, that this would apply.
Representative Hardaway.
Thank you, Mr. Chairman. And this is one that has a lot of nuances, so I had to kind of think through some of them. But at the end of my little train of thought, I have to go with the chairman that in this particular case, that I value first responders as first responders. And law enforcement is trained and prepared to deal with physical violence. And that's not saying that it's right, but they sign up for the possibility of violence. My nurses don't. My fire department personnel, my EMTs, they don't. Okay? So trying to think this through and say that an assault towards law enforcement who is better prepared, expectations are such that it's not necessarily in the job description, but it's to be expected as a possible consequence of serving in law enforcement. And I just can't see saying that they are going to be considered in a way that values their service more so than our nurses or health professionals or our EMTs, the other first responders. So I'm going to have to vote no. It's a difficult decision, but I got to vote no on this.
Any other question for sponsor? I'm sorry, Vice Chairman Gillespie.
Thank you. I called the previous question.
Previous question been called. We're voting on House Bill 1881. All those in favor say aye.
Aye.
Opposed, no. No. Ayes have it. Moves on to finance, sir.
Thank you, Mr. Chairman and committee.
Brings us to House Bill, Item 6, House Bill 2380 by Representative Parkinson. Got a motion? Got a second?
Thank you,
Representative
Mr. Chair.
Parkinson,
Can I get a
you're
roll call vote
recognized.
on this, please, Mr. Chair?
I'm showing an amendment.
Yes, sir. Can I get a roll call vote on this, please?
You can indeed.
Thank you, sir.
What amendment number are you showing?
I got, looks like 017721. Is that what you got?
That's what I have.
Okay, yes, sir.
We got a motion and a second on the amendment. Got a motion and a second. We're voting on attaching 017721 to House Bill 2380. All those in favor say aye.
Roll call vote, Mr. Chair.
Oh, I'm sorry, to attach the amendment. Please forgive me.
No problem, no problem.
We have a roll call vote to attach the amendment. Madam Clerk.
Representative Carringer? Carringer votes aye. Representative Davis? Davis votes aye. Representative Doggett? Doggett votes aye. Representative Farmer? Farmer votes aye. Representative Fritz? Fritz votes aye. Representative Glenn? Glenn votes aye. Representative Hardaway? Hardaway votes aye. Representative Howell? Representative Johnson? Johnson votes aye. Representative Lamberth?
Aye.
Lamberth votes aye. Representative Moody? Moody votes aye. Representative Russell? Representative Towns? Towns votes aye. Vice Chairman Gillespie? Gillespie votes aye. Chairman Holsey?
Aye.
Chairman Holsey votes aye. Mr. Chairman, you have 13 ayes, no nays.
Okay, thank you. Amendment passes. It's on the bill. Please proceed, sir.
Thank you, Mr. Chairman, and thank you, committee. I want to walk you through how we came about with this bill. Back about a month or so ago, there was an article in the newspaper that said that you have to have your gun rights or be eligible for your gun rights, rather, in order to get your voting rights back. And so I had a chance to sit down with Commissioner Goins, and let me publicly thank him for sitting down with me. We sat down actually 2 or 3 times, for a lengthy period of time, because I wanted to understand, how we got to that point to where this statement or this idea of you having to have your gun rights back in order to have your voting rights back came about. And he explained it to me, and I understood exactly how he, was able to arrive at that position, or how they were saying that position was arrived. And to cut through it, there was really no reference in our code that spoke to what rights of citizenship are, with the exception of that was referenced in our Constitution that says a citizen has the right to bear arms. And so that's where that reference came from, and that's how that the tie to the right to vote and the right to bear arms were connected. And so, out of that conversation, that conversation came about because of the Supreme Court decision in the Falls versus Goins decision, and where the Supreme Court interpreted our code, which is fairly convoluted. I must admit that in one section of the code that was created in the 70s, it speaks to having full pardons of the governor and other issues in order to get your citizenship rights back, full citizenship rights. And in another part of the code that was entered in 2006, it talks about, all of the things that you have to do in order to get your voting rights back. And the Supreme Court said that, you have to do both, not either or. Now, prior to the Falls versus Goins decision by the Supreme Court, the Commissioner of Elections, they were restoring people's voting rights based on the latter version of the of our law in our code, the 2006 version that spoke to you. Make sure your child support is paid, make sure your restitution is paid, all of those things, and they could bring that information to the Commissioner of Elections, and then their voting rights were restored. So that's how we got here. So what this bill does is it clarifies language in the law that will put us back to how the Commissioner of Election was able to restore voting rights before the Falls decision. That's the first thing it does. The second thing it does also is it allows individuals to go after the rights that they are eligible to go after, meaning that it's not all or none. But if, let's say, for instance, if you were convicted of a financial crime, so you'd never be able to restore those fiduciary duties back, but you should be able to get your gun rights back. Let me explain to everyone what's taken away from you when you are a convicted felon. There are 5 different things. One is the right to serve on a jury, the right to vote, the right to hold public office, the right to execute a fiduciary office, and the right to possess a firearm. 5 different things that are removed from you when you are convicted of a felony in Tennessee. So the second part of what this bill does is it allows you to go after those rights that you are eligible for. Let's say if you were convicted of voter fraud, that shouldn't eliminate your right to be able to protect your family by being able to possess a firearm. Or let's say if you were convicted of a financial crime, that shouldn't eliminate your right. Once you've paid all of your debt to society, of course, that should not eliminate your right forever to be able to vote, or to be able to possess a firearm, or be able to, regain some of the other rights that you've lost. And so this bill has passed 8-0 in the Senate. Is currently on the Senate floor, and I think they're going to have a vote on it possibly this Thursday. And I'm hoping that we get a favorable decision out of here to move this bill forward. Also, let me touch on one more thing, Mr. Chair, if you don't mind. I think that we got 99.9% of the concerns that our election commissioner had. One of the things he was concerned about, I just want to make sure that everybody knows the full story and transparency. One of the things he was concerned about was we may be, facing some lawsuits, during this election if this bill passes. I said, well, so I moved the date to the execution of this bill to after the elections, to January 1st, 2025, to alleviate that concern. The other concern he had was that, there are other areas in the code that speaks to the rights of citizenship. And, and so that's why our wonderful legal person, Michelle, did a great job of drafting this legislation. I think we put the language in there, notwithstanding those other areas of the title that were not opened up. I do understand that there is an effort to clean up, some of those areas of the title over the summer, and I'm fully on board with that. But I think that we can still pass this bill, and we can still go and clean up all of the other areas of the title that are not cleaned up, as have been done with other pieces of legislation that have come out of this committee. So with that, Mr. Chair, I hope that we'll get a favorable vote. Thank you.
I'm sorry, Representative Fritz.
Thank you, Mr. Chairman. And sponsor, you and I have talked about this many times. You know I support what you're trying to do. I do want to correct just a couple things, and I, sir, am not correcting you nor our great election commissioner in saying these, but when we talk about there are only 5 rights, that when we look to our Constitution, it's much more exhaustive than that. And I want to read just a couple things.
Yeah.
I want me and us on the body as record to say that some of these things are tremendously important to all Tennesseans, whether you're a former felon or whether you've never committed any crimes in your life. And so all men have a natural and indefeasible right to worship Almighty God according to the dictates of their own conscience. And no man can be compelled to attend, erect, or support a place of worship or maintain. And it goes on and it says, no political or religious test. In section 4, article 1, this is our Declaration of Rights. The right of a trial by jury shall remain inviolate. And so I can go on and on. I'm not going to read those. I hope the folks that are watching and our kids at home and our grandkids are reading the Constitution. And again, sir, I love you for what you're doing here, and I appreciate you doing this, but we can't let this go past that it's only those 5 things. You know I'm an absolute supporter of our Second Amendment right. Our founders and our framers were geniuses. I think God ordained genius to be able to write those things down, to put the boundaries on government so our rights are not infringed upon. And that includes the right of suffrage. I could have read just a little bit further and got to that. But I would just offer, that's why I think, and as you and I have said before, I think there's an opportunity for us to clean all of this up so we don't take just a nibble at it, but get the whole thing fixed, and let's have Tennessee lead the entire nation in how we do this. So I appreciate your courage on it. But I do think we need to take a full look at it.
Thank
Yes, sir.
Thank you, Mr. Chair, and thank you, Chairman Fritz. I agree. When I spoke about the 5 rights that were taken from you, these are the ones that are taken from you when you're convicted of a felony. And I do agree and understand what you're saying when it comes to our founding papers. So yes, sir.
Leader Lambert.
Thank you, Mr. Chairman. I know we've spoken about this, and I would have made this motion in subcommittee, but I had stepped out for a moment. You know, there are 4 or 5 bills that have come through this year that all try to address different aspects of this. And the chairman has asked legal to spend some time over the summer that really cleaning this entire section up. I've talked to Chairman Doggett on a couple other issues. Quite frankly, I think there's a couple different parts of the code that we keep trying to get right. I mean, every year we put a Band-Aid on it. I mean, dealing with the expungement law, dealing with bail bonds, dealing with, you know, a lot of the other. And this is another one of those that I feel like, and as well-intentioned this is, I mean, you're trying to put a Band-Aid on a much bigger problem here. And I would like to join with you so that we actually solve the entire problem, that we go through the whole code. And instead of having these sections of year here and a year here and a year there, really make it read for everybody, for anybody. And look, I know there are lawyers that I've met with that have worked very hard on these issues to try to help folks. This should be something as simple that any citizen can go in once they've done their dues to society, and they should be able to look at a checklist of things and say, look, this is what I need to do to be able to regain that right or this right or whatever, because they committed the felony, they were committed to the felony. There's a punishment for that, but once it's over, there's a road back to redemption. We've allowed that road to become too cumbersome and twisted instead of straight and easy. So I'm all for rewriting the code, but I don't think just this bill is the way to do it. And with that, I would make a motion for a summer study.
All right, motion and second for summer study. Take a vote, and I'm assuming a roll call vote.
Yes, sir. And can I not speak to that?
Yes, sir.
Thank you, sir. Yes, sir. We did ask for a roll call vote. Mr. Chairman, a couple of things. One, I hate to hear that motion being made. I think it's a bit unfair that motion was made, because I'm sitting here holding legislation that is passed out of this body with the same language, notwithstanding, because other sections of the code were not opened up for legislation. Mr. Chairman, I'm holding your legislation, Mr. Chairman, not trying to put you on the spot. I'm not trying to embarrass anybody, but I just want us to really give this a true shot and true consideration. But Chairman Halsey, this is your language, notwithstanding on House Bill 1909. And this is another one with yours, Mr. Chairman. This is one with the maker of the motion, Leader Lambert, House Bill 1663, your language has the same language mine has in it because we didn't open up every section of the code that needed to be opened up. Here's another one by you, Mr. Chairman, another one by Chairman Doggett, another one by you, Leader Lambert, right here, that opens up House Bill 2188, and some others that came through this committee that were actually passed in this committee this year. And so I'm asking that, the same consideration that was given for your bills, using the same language because all of the code wasn't cleaned up, be given to my bill. And I think that's only fair to ask. Not just that, Mr. Chairman. We have people that have come a long way up here to speak about this issue. And if we send this bill to summer study, that not only will they not be able to speak, but their voices won't be heard. Some of them have representatives that are on this dais, and they want to be heard. They want their representative to hear them. So I'm gonna ask you, please, to vote down the summer study motion, and let's pass this bill out, because we can do both. We can pass this bill, and we can also come back during the summer and clean up the rest of the code. There's not anything saying that we have to do either or. We can do both and I'm asking for that consideration.
All right, taking a roll call vote on to send the bill to summer study. Madam Clerk.
Representative Carringer? Carringer votes aye. Representative Davis? Davis votes aye. Representative Doggett? Doggett votes no. Representative Farmer? Farmer votes aye. Representative Fritz? Fritz votes aye. Representative Glenn? Glenn votes no. Representative Hardaway? Hardaway votes no. Representative Howell? Representative Johnson? Johnson votes no. Representative Lamberth?
Aye.
Lamberth votes aye. Representative Moody? Moody votes aye. Representative Russell? Russell votes aye. Representative Towns? No. Towns votes no. Vice Chairman Gillespie? Yes. Gillespie votes aye. Chairman Holsey?
No.
Chairman Holsey votes no. Mr. Chairman, you have 8 ayes, 6 noes.
All right, bill goes to summer study. Brings us to item number 7, House Bill 2068 by the noteworthy chairman. Do I have a motion and a second? Motion and a second on 2068. Chairman, you're recognized. And I'm showing an amendment. Do you?
Yes, Chairman, 17271,
17271.
is that correct?
That's what I have.
All right.
Do you want that attached now or explain?
Let's get it on.
All right. Do I have a motion and a second on this amendment? Motion and a second. We're attaching 017271 to House Bill 2068. All those in favor say aye. Opposed, no. Ayes have it. It's attached, sir.
Thank you. All right. Am I recognized, Chairman?
You are
All right,
recognized.
thank you. Members, cockfighting is a cruel and really inexcusable criminal industry in Tennessee, in which puts two of God's creatures in a pit together to fight to the death for profit, gambling, and entertainment. Law enforcement can attest that cockfighting is closely associated with other criminal activities, such as drug trafficking, gang activity, and illegal weapon sales. Now, this bill, as amended, and I do want to give thanks to Vice Chairman Gillespie and Chairman Doggett for helping me get this in a much better posture. But it does two things. One, it's a violation of this act as a Class A misdemeanor with a mandatory fine of $2,500. And two, it establishes that an offense to own, possess, keep cocks, aid, abet the ownership, possession, or keeping of cocks of the purpose of breeding, exhibiting, and showing cocks is not an offense. And so, Chairman, with that explanation of the bill as amended, I'm happy to entertain questions.
And it's proof right here that you're not a chicken when it comes to charging into these issues, and I appreciate that. Any
Well,
questions for the sponsor? Representative Hardaway.
Thank you. Mr. Chairman, I wasn't sure what I was going to do on this bill, but when I looked at the Senate sponsors and I saw Lundberg and Yarborough, I'm on board, sir.
Okay, thank you.
Any other question for the sponsor? Leader Lambert.
Well, when I saw the same thing, I
Oh,
was half
no.
there.
All right, any other questions for the sponsor of the bill? All right, if not, we're voting on House Bill 2068. Sending to calendar rules. All those in favor
Mr.
say
Chairman.
aye. Opposed, no. Ayes have it, sir. Goes to calendar rules.
Chairman, I have to tell you, I ordered a chicken and an egg on the internet, and I'll let you know.
So, Mr. Chairman, if I may, personal privilege, is this the last time we'll see you, sir?
In
In
more
this
specific,
capacity.
in this capacity, I think it'll be the last time you'll see me in criminal full. But I hope to see you tomorrow on the floor. Thank you, Chairman.
We love
Okay,
having you.
thank you, sir. That brings us to item number 10, which is House Bill 2794 by Chairman Russell. Chairman Russell, you recognize. You got a motion and a second.
Thank you, Mr. Chairman. I do have an amendment.
I'm sure. Are you showing 017596?
Yes, sir. That's what I show.
Okay, you got a motion and a second. All those in favor of attaching 017596 to 2794, say aye. Opposed, no. It is attached, sir. Please proceed.
Thank you, Mr. Chairman and committee. The House Bill 2794 creates the Tennessee Victims Act, which seeks to create a grant program for law enforcement agencies to improve their solved crimes, thereby providing swifter justice to criminals, more expedient relief for victims, and better public safety outcomes for all Tennesseans. All law enforcement agencies in Tennessee will be eligible for this grant, and the allowable usage for the grants would be hiring more investigators, purchasing technology to improve laboratory turnaround times, and support services for victims. The grant funds would be appropriated to the General Assembly, so if there's a year we don't bring in the revenue as what we'd like to, we would fund less, and if we bring in more, we'd fund more. With that, Mr. Chairman, I renew my motion.
Okay, you heard an explanation of the bill. Any question for the sponsor? Seeing none, we're voting on House Bill. I'm sorry, Representative Hardaway.
Thank you, Mr. Chairman. And to the sponsor, I appreciate the bill. And to my colleagues, at some point, we've got to understand we can't deliver proper justice on the cheap and be willing to spend the dollars that it takes to deliver timely and full justice. Thank you.
All right, we're voting on sending House Bill 2794 to Finance. All those in favor say aye.
Aye.
Opposed, no. Ayes have it, goes to Finance, sir. That brings us to item number 11, which is House Bill 1930 by Vice Chairman Gillespie. Is there a motion and a second? I have two amendments, sir. Which one do you prefer? Well, I'm
The-
only showing one.
Yes, sir. Thank you, Mr. Chairman. It's 013868.
That's what I'm showing. There's a motion and a second on the amendment. We are attaching Amendment 013868 to House Bill 1930. All those in favor say aye. All opposed, no. Ayes have it. Sir, it is on the bill. You may proceed.
Thank you so much. Before I get started, I'm going to just read a brief letter that was sent to myself and others on this topic. Dear leaders, in the wake of the serious juvenile crime in Shelby County, we must get a hold on our youth. It is not their fault that they have no supervision or the wrong supervision. No one likes rules and answering authority, but we all know how beneficial it is in the wrong one. What we have today are parents who have no parenting skills and have abandoned the hard and exhausting work of raising children in these hard times. I understand that, but it does not negate the fact that our youth need guidance. Parents have abandoned the work of parenting, but they have not abandoned the desire to cover up the error of their children's ways. The entire household is benefiting from the spoils gained by the crimes. Somebody knows these kids are not in bed at night. Somebody knows the teenager was not home at 11 p.m. when curfew begins. Somebody knows that the car their teenager brought home was not the family car. Somebody knows who in their household is not attending school. Somebody knows their son or daughter has a provision without proper means. The parents may be negligent, but they are not clueless as to what's going on. They may be complicit. While every parent has the right to govern their home as they please, you, as city leaders, have a duty to protect the citizens of Shelby County when ineffective parenting spills into the community. What this bill as amendment does would require juvenile court judges to assess a restitution order not to exceed $1,000 for any parent upon the second and sequential offenses committed by a juvenile. This is designed to reimburse law enforcement for expenses related to the crimes and incentivize parents to supervise their children more closely following the first juvenile appearance. The restitution for the expenses incurred by any law enforcement agency as responding or investigating the delinquent act will be as follows: no less than $250 for a misdemeanor act, no less than $500 for a felony act, and it shall not exceed $1,000. And if the parent is found indigent, then the parent or guardian can work the restitution off in community service. With that, Mr. Chair, I renew my motion.
Okay, you heard an explanation of the bill. I believe there's somebody here to speak to the bill. Is there a Jasmine Miller here? Please come forward. We're going to go out of session. Ms. Miller, there's a button right there to push and should turn the light red for you, and please announce who you are. You have 3 minutes, and then we will open up for questions.
Just to check, I think Rafia McCormick is also on your list.
I don't have that, I don't believe.
When I checked with your office yesterday, they said they had received it.
We do. Okay, thank you. We do.
Okay,
Yeah,
great.
Go ahead and come up then, please, also.
All right. I can get us started. My name is Jasmine Miller. I am a staff attorney at the Youth Law Center. We are a national nonprofit organization that works on child welfare and juvenile justice issues, and I work here in Nashville, Tennessee. I will just say that core to my work is the belief that quality parenting is the #1 most important intervention we can be providing to all of our youth. But I believe that this bill will actually cut against the provision of quality parenting to our young people. A few things I just want to emphasize about the language of this bill. The financial penalty is mandatory, okay, for a second or subsequent act. So there's no judicial discretion in deciding whether or not to impose the financial penalty. The financial penalty will be ordered against a parent, legal custodian, or guardian. I think Representative Fritz and Johnson and a few others brought up in subcommittee some concerns about the possibility that this language would disincentivize family members from stepping up to take care of young people, potentially young people who might otherwise go into foster care. And I do believe that DCS clarified that that legal custodian language does not apply to a foster parent, but I really want to emphasize that that language does apply to people who step up through legal custody or guardianship to prevent the child from going into foster care. So we have a lot of young people where their family members step up to prevent them from going into foster care, who would be considered legal custodians or guardians under this bill. The financial penalty is called restitution to law enforcement, which is a little bit strange because there is no other place in our code that I am aware of where we give restitution to law enforcement rather than restitution to victims. The penalty must be at minimum $250 for a misdemeanor and at minimum $500 to a felony. So the range is $250 to $1,000 for a misdemeanor and $500 to $1,000 for a felony. And the bill explicitly applies to all offenses, no matter how minor. I do want to emphasize, we already have restitution in the code. So we have victim restitution. Juvenile court judges are required to order restitution when victims have suffered financial damages from crimes. We also have various other fines and fees. So we are already putting financial penalties on parents who come into contact with the juvenile justice system. I'll note that a number of conservative groups have come out against fines and fees for young people. ALEC, the American Legislative Exchange Council, has a model resolution about getting rid of fines and fees for young people. R Street, Americans for Prosperity, have also endorsed reducing or eliminating fines and fees for young people because they're ineffective. I do want to talk on briefly about a couple of scenarios that I think might be unintended. But under this legislation, if you're a parent who turns your own child in for having committed an offense, you would be fined. If you are a family who is struggling with your child's drug and alcohol addiction, you're going to get fined every time your child, potentially is caught, for on possession or something like that. And you're not going to have an incentive to turn your child in or go to the court for help because you're going to get fined every time that happens.
Okay, Ms. Miller, there's your 3 minutes and we're going to have questions. So you
All
can
right.
probably continue when that happens. Okay, ma'am, you're next, please.
Thank you. Thank you for granting me the opportunity to speak on House Bill 1930. My name is Rafia Muhammad McCormick, a resident of Rutherford County, and someone who has experienced the devastating impact of violence in our community. As a parent who lost a child to violence, I've dedicated myself to volunteer work with organizations focused on supporting victims and preventing violence in the community. In addressing House Bill 1930 aimed at juvenile delinquency, I must express my concerns about the potential negative impact of fines and fees on struggling families. This bill fails to fully comprehend the complexities that lead young people into the criminal justice system. Punitive measures such as those proposed in HB 1930 exacerbate rather than alleviate the challenges faced by struggling families. Let me share a personal story to illustrate this point. One of my now thriving adult children was diagnosed with oppositional defiance disorder at 12 years old, leading to multiple conflicts inside the home, sibling rivalries that were often violent, and involvement with the juvenile system until she was 16 years old. As a parent, I felt overwhelmed balancing work and household responsibilities while trying to provide necessary support. Punitive fines and fees would have only compounded the financial burdens I already was incurring when I missed time from work to accompanying my child to hearings, as well as counseling services, thus diverting resources from vital support systems and worsening the conditions contributing to my child's delinquency. Instead of punitive measures, we need comprehensive programs that engage families in treatment, rehabilitation, and reentry planning. Research underscores the importance of loving, supportive relationships for youth accountability, healing, and successful reintegration. Such programs made a significant difference for my family, providing a sense of support and guidance. Data highlights the vulnerability of families facing health challenges, educational barriers, and economic instability to juvenile justice system involvement. Initiatives should alleviate those struggles and foster nurturing environments for positive youth development. Redirecting resources towards preventative measures, community-based interventions, and supportive service can break those cycles and delinquency and build resilient families. As a directly impacted person myself and a victim's advocate, I know firsthand that for many victims, the most important feeling is that the person that harms them does not desire to harm them or others again. That comes through rehabilitation, not punitive fines and fees. In summary, House Bill 1930 overlooks the root causes of juvenile delinquency and places undue strain on struggling families. Tennessee should prioritize family engagement initiatives that provide support resources and guidance to parents and caregivers. By embracing family-centered approaches, we can empower families to play an active role in their children's rehabilitation and successful reintegration into society, leading to improved outcomes for youth and communities. Thank you for your attention.
Thank you. All right, questions for our visitors. Representative Johnson.
Yes, one of the things you said really resonated with me, and that's again, as I think I mentioned this last time, but as a teacher, I had a lot of students, often either foster care kids or kids that were living with the guardian that you spoke about. And oftentimes, because these were big teenager kids, the parent would call to report the child themselves, and because they just needed help and they didn't know any other way to get help. So now we're saying that if the parent calls to report their child, they're actually going to get that penalty fee. I can tell you, to their own risk of their own health and well-being, for them not to make that call could be very devastating. And I fear that this, because it will cost them to make that call, it will cause a problem with them being able to try to get some help. So is that how that would work? They would be charged or penalized?
Under the language of the current amendment, which states that the fine is mandatory, the judge has no discretion, which means that if a parent calls and it's on a second or subsequent offense and the child is adjudicated delinquent, they are assessed the fine.
Thank you.
Representative Carringer.
Thank you, Chairman. It's really hard, I mean, to know, a lot of these parents are single moms and are working and doing all they can, best they can to raise their family and work. And so incurring an amount of money, I mean, they don't have that extra money to come about. And so my Knox County juvenile judge, because we understood there was another amendment that actually had the word shall, or the one we're talking about is shall. There's another amendment that was drawn up that said may. And he was in total support of that. And with being on foster care review board in Knox County for a while, I completely understand what you're saying. I mean, a lot of the parents are doing the best they can, and I do share that same concern of then the parent not calling in, because I worked in the school systems and we actually had parents that called and said, "Hey, I brought my child to school. Are they there?" No, they weren't there. So I can't vote. I could vote for it if it had the amendment that said the court may enter an order of restitution, but I can't support the bill with it saying shall. So,
Representative Glenn.
Thank you, Mr. Chairman, and thank you for being here today to testify. I just got two quick questions. Have you seen this, and it doesn't matter who answers, have you seen this particular act or penalty in any other state? Have you seen it enacted anywhere else besides?
I haven't done a 50-state review. I'm not aware of other states that have this particular type of financial penalty. We do, in our own code, have many other kinds of financial penalties, but and I'm not aware of this particular type. I will note that Texas got rid of fines for youth in the youth justice system, and Louisiana got rid of fines and fees. So we have some real diversity, I would say, in terms of states, and there's been a movement towards reducing fines and fees because they are not particularly effective, and because of all the burdens that they can place on families, as Representative Johnson and Carringer both noted.
Okay.
Go ahead.
And the second question, ma'am, you mentioned, I'm sorry, I don't remember your name, I apologize. You mentioned resources. You'd like to see resources that could help. Can you just give us a couple of resources you'd like to see or you've seen that actually help kids and parents to?
Yes, most definitely. I can share from my own experience. When we were in this situation, resources that helped my family was family therapy services. I also was provided with Love and Logic counseling because I had a child that was oppositional defiant disorder. It made parenting her challenging. That would be different than parenting a child that did not have that kind of disorder. So I learned through a Love and Logic 12-week course on how I would use choices for my child rather than punitive measures, because an oppositional defiant disorder child does not respond to punitive measure. They respond to choices.
I'm lost.
Well, no, I was waiting to be called upon before we go back in session.
Wait just a second. Was there somebody else on the list that I missed that wanted to address these two ladies? Okay, but before him, I had it down. I missed somebody. Representative Glenn, you're through, right? Yes. Okay, Representative Hardaway, go ahead.
Thank you, Chairman, and thank you for being here, the both of you. Ma'am, you did not finish your initial statement. What did we miss?
I could talk about this for a while, but I'll try to keep it brief. I think when we think about, again, some of these unintended situations where people end up being fined, the grandparents and extended family members who make a decision to step in and take legal custody of children who have gotten into trouble, they get fined if they can't fix the situation immediately. And that obviously creates sort of a disincentive for family members to be willing to step in. And again, that is a scenario that often happens to keep young people out of the foster system, out of state custody, because it's not uncommon, right? It's particularly on minor offenses. One of the ways that young people might come into the detention of the juvenile court where they find out, oh, hey, there's something going on in the home. Sometimes that might be because that young person commits some sort of misdemeanor shoplifting, that kind of thing. And that comes to attention to the juvenile court. And then the juvenile court looks at that and says, okay, what can we do to make sure you get better supervision? Can we find a family member because, what's happening at home isn't okay. Maybe you're being abused or neglected. And so at that point, right, you have some choices. You could try to find a family member, and that would be preferable. If you can't find a family member, then they end up in the foster system. And so that family member who steps up under this bill would be potentially the person who would be fined. That the initial situation that led to that young person getting in trouble was, not their fault. And then I do think that, when we're talking about young people, particularly ones who have experienced a lot of abuse or neglect at home, it's not uncommon for young people to act out, for a few years while they're kind of figuring out how to make things work, right? And so to sort of say, if you can't fix it overnight, we're going to fine you, I think seems counterintuitive to trying to really help that family thrive and become, find a permanent and stable situation for that young person.
Okay, so in essence, we're dissuading families from stepping up, keeping children out of DCS. Just a couple of questions, Mr. Chairman. On the restitution quote to law enforcement, is that a new concept?
As far as I'm aware, we don't have under any other restitution to law enforcement in code, because restitution is for victims. And I do think that this raises a lot of interesting questions. For example, if a court orders restitution to a victim and restitution to law enforcement, and there's some issue with trying to pay that full amount, like who gets paid first? Typically, we say that the restitution comes before all other costs and fees, because restitution is about making the victim whole. When we put law enforcement into that category, then it kind of gets muddled in terms of our priorities. I would also note that this creates a weird, you might call it a perverse incentive around law enforcement receiving money for arresting children. If we were to take sort of the more emotional law enforcement bit out of it and just think of it as a business proposition. If I'm running a business and I say to my employees, I'm going to give you bonuses for every repeat customer in the store, there's two main strategies that you would use. One is to get customers to come back in the store to come back. Another is to increase the number of first-time customers in the store. So if we put that in the law enforcement context, we end up kind of incentivizing law enforcement to police and arrest children, because that potentially becomes a pretty significant revenue source. It's $250 minimum every time you bring in someone who's been here more than once. Again, nothing in the bill that says this is about serious crimes, $250 for any misdemeanor, and that's a little bit concerning.
All right, thank you. And Mr. Chairman, and to the bill sponsor, I just can't figure out why we would want to put what would in essence be a bounty on children who have problems that children have, but some are more severe, some are going to be more exaggerated than others. And instead of rewarding the parents or the guardians that step up and want to engage our law enforcement or the courts or other agencies by reporting that they do have a problem that they need help with, we're disincentivizing and we're dissuading that from happening. For that reason, Chairman Gillespie, I cannot support your bill as is. Thank you.
All right, all right. Would everybody be happy if we changed the shall to may? No. Would you be happier?
Happier.
Well, some would be. Some would be. All right, some would be. To get that done, we've got to take an untimely filed amendment. I got to get back into session. Hold on. We're back into session. To do that, we need to consider our actions. Reconsider our actions on Amendment 013868. And I have a motion and a second. Are all those in favor? Say aye. We have reconsidered. Now we want to consider attaching Amendment 014198. And there's a second. All those in favor of consideration, say aye. Aye. Opposed, no. Ayes have it. Now we need to attach this amendment to this bill. We are attaching 014198 to House Bill 1930. All those in favor say aye. Aye. Opposed, no. All right, we have done a U-turn and the road is clear. All right. We are also back in session. Representative Hardaway.
Thank you, Chairman. Are we now in a position, a posture on this bill that's identical to what's in the Senate, what moved in the Senate?
I will let the sponsor of the bill answer that question.
Thank you, Mr. Chair. Yes, that is my belief. Yes, sir.
And that in essence allows for judicial discretion. Is that correct?
Go ahead.
Yes, that is correct.
All right. And is there, will that judicial, and Mr. Chairman, I don't know whether the sponsor wants to refer this to legal, but with that judicial discretion allow parents, guardians, et cetera, to report without fear of how many times they have to engage, without fear of being burdened with restitution to law enforcement agencies? Or is restitution to law enforcement agencies still language that's in the amended version of the bill?
Go ahead. Thank you, Mr. Chair. The question that you're asking me is if after you've already been adjudicated of multiple delinquent acts, would the parent have to pay the fine? That would be up for the judge to decide.
Well, I'm asking because I'm assuming from the summary of the bill as amended that there's still the option for the fine being paid or for there to be some type of community service work. I don't see how or what type of community service work will allow restitution to law enforcement agencies unless you're going to make them work for the law enforcement agency.
Thank you, Mr. Chairman. So that was in the bill that we just got, or the amendment before, and it's in the original and it's in this one. So the court must order the child's parent, legal custodian, or guardian to perform community service work in lieu of restitution if they're found indigent. So that is, again, at the discretion of the judge. So I cannot answer that question because I am not a judge.
All right, I'll wrap by saying I got an issue with a bounty on children. And if we took that restitution out, then if Chairman Halsey asked me if I was good with this bill. I'd tell him yes.
Representative Glenn.
Thank you, Mr. Chairman. I just got one question. What is the end state for this particular bill? What are you what are you attempting to gain by penalizing the parent for delinquent kids?
Thank you, Mr. Chairman. I had a hard time understanding you. Did you say what is the what, can you repeat that? Sorry.
Yeah, what are you attempting to gain by penalizing the parents for a delinquent child?
So again, this is after the second act. The whole premise is if your child is driving a car that cost $100,000 and you know your child does not have $100,000, you know something. If your child is out at 2 o'clock in the morning, you know something. It's trying to get the parents that literally are turning a blind eye, that simply just do not care, to get them to pay attention to their child's welfare. And where this comes into play is their child's welfare when they're out graffitiing something at 4 o'clock in the morning. That is not a victimless crime. Someone is being affected by that, and the parent knows about it. And this only comes into effect after they've already been adjudicated once. This isn't like, oh my gosh, I didn't know anything was going on. This is after they've already had interactions with the criminal justice system.
Move previous question.
Previous question been called on House Bill 1930. We will be voting to send this to Finance, Ways and Means. All those in favor say aye. Aye. Opposed, no. The ayes have it. Goes to Finance, Ways and Means, sir. Brings us to item number 12, which is House Bill 2206. You have a motion. Is there a second? You got a motion and a second by Vice Chairman Gillespie. You're recognized on 2206, and I'm showing an amendment. That's what I show. All right, we have a motion. Is there a second on the amendment? We're attaching 014549 to House Bill 2206. All those in favor say aye. Opposed, no. Ayes have it. The amendment is on the bill. Please explain, sir.
Thank you so much, Mr. Chairman Committee. This one is a little bit, I think, easier. All this would do would allow law enforcement agencies to transport human remains for the purpose of training. Current law prohibits law enforcement from transporting human remains. Currently, it's a Class E felony. It would be required to conduct the training in accordance to best practices and procedures, including secure storage, use of the remains as training aid, and proper disposal. I've had lengthy conversations with the TBI, Shelby County Sheriff's Office, the University of Tennessee Body Farm, the Health Department, and numerous others. With that, I I renew my motion.
All right, Representative Fritz. Question be called on the bill. We're voting on House Bill 2206. Send to Gov Ops. All those in favor say aye. Aye. Opposed, no. Ayes have it. Goes to Government Ops. That brings us to item number 13. You ready? All right. We got a motion and a second on House Bill 2684. I have an amendment I'm showing.
13530.
That's what I'm showing. There's a motion and a second on amendment. We are attaching 013530 to House Bill 2684. All those in favor say aye. Opposed, no. Ayes have it. The attachment is made. If you will proceed there, Chairman.
Thank you, Mr. Chairman. So what we're changing here is the date, the amount of time that's listed last year. I talked about it in subcommittee. We did some things about how law enforcement would have to have entered into available state and federal databases, such as NCIC, for a failure to appear on felonies, and then the A and B misdemeanors that were violent or sexual in nature. We are adding here 10 business days. We're changing it from 10 days from the failure to appear to 10 business days from the date of the failure to appear.
All right, any question for the sponsor? Seeing none, we're voting on House Bill 2684 to send to calendar rules. All those in favor say aye. Aye. Opposed, no. Ayes have it. Sir, goes to calendar rules.
Thank you.
Brings us to item number 14, which is House Bill 2693.
Second.
Have a motion and a second, also by Chairman Doggett. I show an amendment on that as well.
16694.
Motion and a second on 016694 to attach to House Bill 2693. All those in favor say aye. Opposed, no. Ayes have it. It is attached. Please proceed, Chairman.
Thank you, Mr. Chairman. What we're doing here is stating that the District Attorney General is not required to file a complaint for involuntary care commitment or treatment if the defendant is found incompetent to stand trial due to an intellectual disability. And it also requires 2 certificate of needs to be submitted to the court if the defendant is to receive any type of involuntary care treatment.
All right, you heard the explanation of the bill. Any questions for the sponsor? Representative Johnson.
Just want to bring up again that what I'm being told by folks is there's no place for those with intellectual disabilities to go. And the fear is that they will go to jail and the services won't be there for them.
Sponsor. You have a response?
Oh, we are working with the Department of Intellectual and Developmental Disabilities in this, so they would eventually be remitted into their custody, from what I understand. And it's not the intent for them to sit in a jail somewhere and not receive any type of treatment.
Thank you. I appreciate that that is not the intent, but until there's something in place, I have a hard time voting for this. So thank you for the information.
All right, any other question for the sponsor of the bill? Seeing none, we're voting on House Bill 2693 to send to calendar rules. All those in favor say aye. Opposed, no. Ayes have it, goes to calendar rules.
Thank
sir.
you.
That moves us to item number 15 on the calendar, which is House Bill 2863. You have a motion? You have a second? Representative Towns, you're recognized, and I'm showing an amendment.
Mr. Chairman, if you don't mind, would you read that amendment, please?
015372. Is that what you show?
Yes, sir. I don't have it right here with me, so I want to have it read as well by the. Do you mind? Oh, my eyes are-
All right.
Thank you. Yes, that's it, Mr. Chairman.
Okay, we're going to attach amendment 015372 to House Bill 2863. All those in favor say aye. Opposed, no. It is attached, sir. Please proceed.
Well, Mr. Chairman and members, thank you very much. The rewrites the bill. The amendment requires a person who commits a second or subsequent offense of aggravated reckless driving to attend a driver's education course and have their driver's license suspended for at least 6 months, but not more than 1 year. It requires law enforcement to seize person's vehicle upon a second subsequent of aggravated reckless driving if the perpetrator of the offense is the sole owner of the motor vehicle and the motor vehicle is not subject to any interest or a secured or interest up by a secured party. What we're getting at is obviously happening everywhere is this reckless driving that young people are doing, and these donuts and this craziness with guns hanging out of the car. Is trying to get the attention, and hopefully we can retrain the young people and whomever on how to drive on our roads so that they're protected. People feel safe when they're driving. And in essence, Mr. Chairman and members, that's what the bill does.
Okay, any question for the sponsor of the bill? Representative Fritz.
Thank you, Mr. Chairman, and thank you for the bill. Reckless driving, could that include certain speeds, and what would those speeds be? Do you know? Sponsor?
Go ahead.
Legal double check me on this, but as I understand, Representative Fritz, that reckless driving over 20 miles an hour is considered reckless driving as we speak. Okay.
It's
Anything over 20 miles an hour speed limit. Mr. Chairman, you've been in law school. Is that correct? I think it's.
Used to be 30 mile an hour, as I recall, but there had to be some other furtive things that added to it that
Okay.
couldn't be just on speed.
Okay.
Yes, Fritz, Representative Fritz.
So my question is, it says, I'm supportive of what you're trying to do. I just want to make sure we know that 2 offenses of speeding could result in this the way I read it.
You'd have to be charged the very first time around to have that on the record. I can't see that happening.
Okay. Thank you, Mr. Chairman. Thank
Any other question for the sponsor? All right, we are voting on House Bill 2863 to send to Finance and Ways and Means. All those in favor say aye. Opposed, no. Ayes have it. Goes to Finance, sir.
Thank you, Mr. Chairman, members.
That brings up item number 16, which is House Bill 2943, also by Representative Towns.
Thank you, Mr. Chairman, members. Mr. Chairman, members, this
Wait,
bill.
just one second. I
Yes,
got
sir.
an amendment on this as well. That's the amendment I see, 014445. Hey, you're going to have to make me quit doing your work, Representative Towns.
She's took good, Mr. Chairman. But you're my chairman. You're supposed to help me. You're my chairman.
All right, we're going to vote on attaching Amendment 014445 to House Bill 2943. All those in favor say aye. Opposed, no. Ayes have it. Representative Towns, the amendment is on your bill.
And Mr. Chairman, thank you for all that you do. I know you love your members. I appreciate it. Look, this one, Mr. Chairman, before I get into it, this comes from my senator, Senator Cowell, and this comes from a real incident that happened in the city that she wanted to address. And so this amendment rewrites the bill, amends the bill specifically that a Class B misdemeanor offense of indecent exposure includes victims from the age of 13 and 17 years old. When the offense is involving a person who knowingly invites, entice, or fraudulently induces a minor into his personal residence or engages in the person's own residence, and in the intended presence of any minor without the consent of the minor, which I don't know if minors can consent to that kind of sexual behavior, and intentionally engages in the following conduct for the purpose of attaining sexual arousal or gratification: exposure of such person's genitalia, buttocks, et cetera, et cetera, et cetera. Okay, Mr. Chairman and members, what happened is that there was a young girl, according to Senator Cowell. She had I'm going to say a slumber party, bunch of young girls over. Her dad came in and told her to go to her room and go to bed. The girls were left in the room. He began to expose himself. And however, because they were at a certain age, the law did not catch them in that. This will take it up to 17, where it will allow them to be prosecuted at that age. And as I said, it comes from a real deal that happened in Senator Cowell's area and district, and that's what it's seeking to do, to expand the dragnet so we can catch people that are abusing children at that age.
Okay, you've heard the explanation of the bill. Any question for the sponsor? Representative Fritz.
Thank you, Mr. Chairman. And again, sponsor, I appreciate you bringing this bill. I still have issue. We talked about this last time.
Yes, sir.
We're using words in here that we say without the consent of the minor. And when I read it, it doesn't, I have trouble with those words already. I'm completely 110% behind you, brother, in what you're trying to do. But I think we should be really careful about saying without consent of the minor. We're talking about 13-year-old kid. They can't consent to nothing, I think. And maybe we hear again for legal, but just a thought on that.
Okay, any other questions for the sponsor of the bill? All right, hearing none, we're going to vote on House Bill 2943. Oh, I'm sorry.
Thank you, Mr. Chair. I apologize. I wasn't clear. I rambled a little bit. Could we hear from legal again on what that means, that without the consent of the minor? Because that troubles me greatly.
Okay, without objection, we'll go out of session for legal.
Michelle Fogarty, Legal Services. The language is consistent with our rape of a child statute. Tennessee recognizes the close in age exception, which means that our state law does not criminalize consensual acts if one of the parties is 13 to 17 years of age and the other party is less than 4 years older. So this makes it consistent with that.
Thank you, legal. Just one follow-up on that. Then down on the last entry on the first page, and we talk about 18 and 13, and I understand what we're saying there and what it references, but are we leaving ourselves in some vulnerable spot legally in having those ages in and still talking about consent?
The section you're referring to is current law and applies to a different subdivision other than what's in section 1. So it maintains the current law as it is. This bill adds a new subdivision, A1B, Roman numeral 3 and 4, and then specifies that the new subdivisions only apply to when the defendant is 18 years of age and the victim must be at least 13, but no more than 17. And as far as the rest of your question, that would be for a court to determine.
Thank you. I just want to make sure we get that on the record. Thank you, Mr. Chairman.
Okay, another question for legal while we're out. Representative Carringer? Oh, you didn't have a question. Any other questions for legal while we're out of session? Seeing none, we're back in session. Any question for the sponsor of the bill? All right, we're voting on House Bill 2943 to send to calendar rules. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. Moves to calendar rules, sir. That brings us to item number 17, which is House Bill 1520 by Representative Hardaway. We got a motion?
Thank you.
I heard a second. I'm showing an amendment, sir. How about you?
I am, sir, and I'm in, what I don't show is my House Amendment number. I was looking at the Senate amendment.
I'm showing 005582.
It's on my paper down there that I gave Joe.
Thank you, Mr. Chairman, and thank you to.
Is that what you
Lady
show?
Carringer. Yes, sir.
All right, we need to attach this amendment on the bill. Is there a motion? There's a motion and a second on attaching 005582 to House Bill 1520. All those in favor say aye. Opposed, no. Ayes have it. The amendment is attached, sir. Please proceed.
Thank you. And we've all heard and talked about blended sentencing a number of times. This establishes an extended juvenile court jurisdiction pilot program. It would exist in Shelby and/or Davidson County. It's permissive. It requires 2/3 of the majority of a county legislative body, and the county would pay the freight, pay the cost. With that explanation and the added caveat that we're working with the Senate, there's a bill that's moving in the Senate, and this is a placeholder backup to that bill.
Would you repeat that last sentence that you said, Representative Hardaway?
Yes, sir. We're working closely with Senate sponsors of a similar bill, and this is a backup to that bill.
Okay, Leader Lambert. Good previous question. Okay. Previous question had been called on House Bill 1520. Well, all right, We're voting to send House Bill 1520 to finance. All those in favor say aye. Opposed, no. Ayes have it, sir. You skated through that one.
Thank
All
you.
right. That
Mr.
brings us
Chairman.
to item number 18, which is House Bill 2961, also by Representative Hardaway. You have a motion and a second?
Mr. Chairman, this is clear cut. It sets up a TASER study on whether or not, if so, how, why, and when, that the Shelby County, would create and establish a crime lab, what the impact of that crime lab would be on public health, safety, education, housing, economy for citizens and visitors, and not merely how it impacts the rest of the load, the crime lab load for the rest of the state, but for the region. We would study things such as if we're able to use the new technologies, including AI and quantum computing, and have fewer personnel, create more capacity than the regular system, that we might be able to have enough to serve the rest of the state and our contiguous states. With that, Mr. Chairman, I'll ask that you support me and these 70, 80 or so co-sponsors.
I was going to say, if that's any indicative of the movement of the success of it, you should get that done now. Vice Chairman Gillespie.
Thank you, Mr. Chairman, and Representative Hardaway, thank you so much. We've talked about this a lot, and I 100% support it. And just in case the rest of the committee needed to hear this, this is something that all of my local law enforcement, Memphis Police, Shelby County Sheriffs, Germantown, Collierville, Millington Police Departments, et cetera, all desperately need. And it would really help with the speediness of investigations. And I truly believe it can help close the clearance rate overall that we are struggling with. That is the big issue. Because if the police can't gather enough evidence to take it to court, then it's not going to court. And so I just wanted to make sure all of my committee members knew that, and the people watching and listening understand that we at least need to know what we're dealing with here. I know there's certain crimes and certain offenses that are processed at TBI and others are not. I know that Nashville has a lab and other big cities across the country have their own labs. And this will just allow us to exactly know what we're working with. And so I thank you.
Representative Towns.
Mr. Chairman, thank you. And I have to echo my colleague's comments out of Shelby County. And if you all remember, we had that major backlog of rape kits, okay, that were never processed in a timely manner. And eventually, you know, justice delayed can be considered as justice denied. And being that large city down there, we have a lot of activity. And this would certainly help us, and the surrounding areas too, to help surrounding areas too, for us to expedite process this stuff. And if it's not processed, lawyers, prosecutors don't have anything to hang their hats on. So we really need this thing down there. We had it, I forgot how many years we had it down there. For some reason, in somebody's infinite wisdom, they decided to take it away. That's not a good idea in a growing major city, $1 million folk or more, you know. So we hope you all can support it because it's needed in order to give justice to the people of Shelby County and the people of Tennessee. Thank you, Mr. Chairman.
All right, we're voting on House Bill 2961 to send to finance. All those in favor say aye. Opposed, no. Ayes have it, sir. Move to finance. That concludes our calendar unless there's any opposition to spending more
Chairman,
time. Is there a motion to adjourn?
Let me make it clear that this bill has been put together with your co-chairman, Gillespie, and I thank him for the work that he's done.
You're welcome.